Hello and welcome. Today we shall discuss a very hot current affairs which is going on in the country surrounding the relevance of the places of worship, that is Special Provisions Act 1991. This act has become very critical in the present context of current discourse surrounding a series of claims by certain Hindu groups on Islamic places of worship. This includes Gyanvapi Mosque, Shahi Idgah in Mathura, latest Sambhal in Uttar Pradesh, and the last being the Ajmer Dargah. On 19th November, to come to that, let's have a context of what has been happening in the recent period. That on 19th of November, a petition was filed by a Supreme Court lawyer, Vishnu Shankar Jain, in the court of civil judge of Sambhal, Uttar Pradesh, claiming that a temple existed at the site of Shahi Jama Masjid of Sambhal. Listen, we always talk that our judiciary system is so runs in a such a small pace that a case takes sometimes 20, 30, 40 years even. But look at the promptness of the case here. On 19 November, the petition was filed. On the very day, the trial court judge provided a judgment ordering to conduct a survey, and the survey was undertaken on the same day. Again, on 24th of November, another survey was being conducted, over which there was protest from the other side. And there was a clash between the police and the protesters, which claimed 4 lives. At the next hearing on 29th November, the trial court had granted to complete the report in 10 days. However, concerning the survey of Sambhal Jama Masjid, the Supreme Court directed the trial court to stay the proceedings of the matter and advised the government of UP that in court peace and harmony must prevail, unquote. Further, the bench comprising of the Chief Justice of India, Sanjeev Khanna, and Justice Sanjay Kumar was hearing a special writ petition filed by the Mosque Management Committee of Sambhal, which sought an ex parte ad interim stay on the operation of the 19th November order of the trial court. Earlier we know that in the Gyanvapi Mosque dispute, the then Chief Justice of India, D.Y. Chandrachud, had observed that since the survey was purely investigatory in nature, it would not affect the religious character of the mosque. It means that the 1991 Places of Worship Act states that the status of any place of religion cannot be converted or cannot be changed or cannot be altered, as it is on 15th of August 1947. That is, the status quo must be maintained, what it was on the day of independence. But here Chandrachud gave such an observation which opened a Pandora box, leading to so many further claims of mosques being constructed at different places by destroying Hindu temples. As a part of the bench, the Chief Justice, the then Chief Justice, Chandrachud, had observed that the Places of Worship Act prohibit to change the nature of the place of worship, but it has not prohibited, his interpretation is that it has not prohibited to have an archaeological survey to ascertain the fact whether the claims made by the Hindu groups are correct or not. That interpretation of D.Y. Chandrachud led to a series of claims by the Hindutva groups in different Islamic sites of religion to claim that beneath those places earlier there were Hindu temples. Had he closed at that point that this contradicts the 1991 Places of Worship Act at that point, then perhaps this series of claims and counterclaims leading to protests, counter-protests, and even lives of so many innocent people, leading to a communal tension in the country, would not have arisen. Incidentally, here in this context, I would like to remind you that Justice Chandrachud was also a part of the 5-judge bench which decided the Ayodhya Babri Ram Janmabhoomi dispute case in 2019. While proclaiming Ayodhya judgment, the Supreme Court bench referred to 1991 Act. Quote, to our history and to the future of the nation, in resolving the character of places of public worship, the Parliament had mandated in no uncertain terms that history and its wrongs shall not be used as tools to oppress the present and the future, unquote. The 5-judge bench held in clear terms that the 91 Act and the prescribed cut-off date of 15th August 1947 was intended to acknowledge that India's independence presented an opportunity to heal the wounds of the past. The court, that is, to heal the wounds of the past, the court strongly stated that it could not allow history. In that judgment, in Ayodhya judgment, Supreme Court bench is stating that the court strongly, it could not allow history to be used as a tool to resolve old disputes and starts conflicts anew. Chandrachud's observation in the Gyanvapi dispute, on the other hand, seemed to apply that a survey is permissible despite the court's stance in the Ayodhya judgment and to decide the character of the mosque. These interpretations of 91 Act, this interpretation of 91 Act has affected the judgments of the district courts. They were encouraged and they took up whichever petitions came in the name of mosque and temple dispute. It has brought the core principles of Places of Worship Act in peril. After that, a series of challenges are arriving in the wake of Janvapi, such as Shahi Idgah Mosque in Mathura, and even now the Ajmer Sharif Dargah. So let's discuss the 1991 Act and its context. Let's first explain the objectives of this 91 Act. This 91 Act, it was enacted to preserve the religious character of places of worship as they stood on 15th August 1947. The status quo must be maintained. It prohibits the conversion of any place of worship and bars courts from entertaining any legal cases of such nature. Ram Janmabhoomi Babri Masjid dispute was considered to be an exception as per this act because it was already under litigation at the time of enactment of this 91 Act. Number two, what is the rationale behind this act? The law intended to promote communal harmony by keeping intact the religious status quo as of 1947 and preventing disputes over historical places of worship. This was particularly significant in the aftermath of the Ram Janmabhoomi movement, which gained momentum in the late 80s and 90s. Let's see the present context of claims. Let's analyze the present context of claims. In the recent years, the Hindutva groups have reclaimed that some mosques to be alleged Hindu sites. Janvapi Mosque at Varanasi was claimed to have been built after demolishing a Visheshwar temple. Shahi Idgah at Mathura alleged to have replaced a Krishna temple. Ajmer Dargah asserted to be linked to a Hindu shrine in the distant past. Let's now see and analyze what are the legal challenges. Petitions have been filed in courts seeking surveys or archaeological studies to establish historical claims. Secondly, these efforts challenge the constitutional validity of the 1991 Act by arguing that it prevents the correction of historical wrongs. In this context, let me state that already a petition in Supreme Court has been filed by ex-Rajya Sabha MP Subramaniam Swamy and Ashwini Upadhyay and others, challenging the legality of the 1991 Places of Worship Act. To listen to that, the Chief Justice of India has formed a special bench comprising of him and of Sanjay Kumar, Justice Sanjay Kumar, which will hear the case tomorrow, that is on 12th of December. That will ascertain what will be the course of history of communal harmony in this country, whether this sort of communal disputes should continue or it would make a full stop to that. On December 12th, after hearing that, the special bench consisted of the Chief Justice of India, Sanjeev Khanna, that would determine the course of action. Let's see what is happening. Thirdly, a broader Hindutva narrative. The ideological push behind these claims tied to a larger project of reshaping India's historical narrative very often described as the recovery of a Hindu past allegedly suppressed during Islamic rule. But to be fair enough and impartially looking at this, the different criticisms and concerns are, number one, there is erosion of secularism. Very recently, in a judgment where even Subramaniam Swamy was a part of that petition to remove the concepts of socialism and secularism from the preamble, since it was inserted during the time of Indira Gandhi's emergency period. They had petitioned to remove this term socialism and secularism. But the Supreme Court had rejected that plea, clearly stating that secularism is an integral part of Indian Constitution and the preamble is also the basic structure of the Constitution. So both the term socialism and secularism would remain in the preamble of the Constitution. So this is a serious matter. This is affecting the secular nature of the country. The secular fabric has been affected. Number two, legal and ethical dimensions. The 1991 Act is seen as a safeguard against the continuous litigation and conflict. It was to stop all these things. Number three, revisiting past grievances ignores the evolutionary nature of cultural and religious integration in Indian society. Number four, communal polarization. The resurgence of such claims is often seen as a political strategy to mobilize communal sentiments, especially during election, to get electoral benefits. So what is the way forward? We conclude by stating this. What are the ways forward? Number one, upholding the rule of law. The 1991 Act should be respected as a binding statute that aims to foster peace and communal harmony. That will be decided on 12th of December. The Supreme Court's interpretation and the adjudication of related cases will be pivotal. Number two, dialogue and reconciliation. India must prioritize, as a democracy, India must prioritize dialogue and reconciliation over historical grievances to preserve the pluralistic ethos. Number three, we must focus on development. Instead of fueling divisive narratives, efforts should be directed towards addressing pressing issues such as poverty, education, healthcare, etc. These ongoing disputes challenge the delicate balance between India's history and its commitment to secularism and pluralism. How the nation navigates these tensions will shape its social fabric for years to come. Thank you.